All right. Good morning, everyone. As Dwayne said, my name's Margaret Waddell. I'm one of the legal team that have been working with the plaintiffs in this proceeding and with the Survivors Committee. Before we get going, as Dwayne said, there are some mental health workers here in the room, but a lot of people will have a lot of feelings after today, and you may want some help afterwards. Up on the screen, we've got the reference to the Hope for Wellness. Oh, can you hear me now?
Does it have to be turned up a bit more? Yeah.
Okay.
So we need to turn it up. The people in the back can't hear.
All right. Is that better now? Okay. So Hope for Wellness is available 24 hours a day to provide help if you need to talk to someone. The phone number's up on the screen, and their website is available. And I understand that the Métis Nation is also going to look to have some people available to assist if after today you're feeling like you need to speak with someone. So we know that this is going to be bringing up a lot of hard memories for people as we talk about what's going on today. And we understand that this has been a lifetime of trauma that you've been dealing with, and we're looking forward to hearing your questions after we do our presentation, and we're here to hear what you have to say and to make sure that you understand everything that you need to know about the proposed settlement. So we're going to start with talking about what the class action is about. The lawsuit that was started originally back in 2005 and which has continued since then covers the harms that the students experienced at Île-à-la-Crosse, and right from the beginning of when the school opened back in the 1860s up until the time that the school closed in 1975-76 before it was taken over by the local school board in 1976. The action alleges that both Canada and Saskatchewan didn't keep the students safe from harm. And now we are at the point where each government has agreed to a settlement, but they're two separate settlements. And before we get into the details of the settlement, this claim does not include the Catholic Church, and it doesn't include individual people who caused harms, who were abusive to the students, who assaulted them or sexually assaulted them. Those claims are not included in this lawsuit. It only deals with the claims against the two governments, Saskatchewan and Ontario. So because the church wasn't sued, there is the ability for anybody who would want to bring their own lawsuits for physical or sexual abuse against the church or the people who hurt them. Those claims aren't being extinguished by this lawsuit. They can still be pursued separately. So this is just about the harms that are alleged to have been caused by Canada and Saskatchewan not making sure that the school was a safe place for you to be, and with all of the harms that were caused by the residential school system in general. So who's included in the class? There's two groups. The main thrust of the claim is for the survivors, the students who went to the school at any time up until the new school was opened in 1976 and taken over. It only includes people who were alive up until December 9, 2003. And I understand that may seem like a weird date. It is a weird date. It has nothing to do with who attended or what was going on at the school. That has to do with legal rules and what's called limitation periods. So the class action was started originally on December 9th, 2005. And for people to be allowed to be included in the claim, they had to be alive on the date that the claim was started or within 2 years prior to that date. And so that's how we come up with the date of December 9, 2003. So any student who was alive as of that date is included in the survivor class. And we know that many survivors have died since then. Their claims can still be pursued, and we'll talk about that more as we come through the presentation, but their claims can still be pursued by either their estate executors, if they had a will, or by the next of kin, if they died without a will. They'll be able to bring a claim forward for to get the benefits that survivor would have been entitled to if they were still alive. The claim is also made on behalf of the family class. This is the intergenerational survivors, the spouses, parents, children, and so on of the survivor class. They will not be getting money directly in the settlement. They'll get benefits. I think I need a different mic. Yeah. Push it back. No, but if I get back, they can't hear me. It's not working. Yeah. Yeah, so this one's way better. Much better. Okay, so for the family class, they're not going to get a direct payment into their own pocket from this settlement, but as we'll come to and we'll explain, in the settlement with Canada, there's a $10 million legacy fund, and the intergenerational survivors will receive benefits through the operation of that fund, which is being created to assist with healing, wellness, language, culture, and community rebuilding.
Hello? Hello? This one is also not working.
Okay, we'll share.
Okay. Problem solving. Hi, everybody. I'm going to go over some of the details of the settlement with Canada now. The first part of the settlement with Canada are the experience payments. So Canada is paying $27.335 million for the experience payments. And for each individual survivor, that means up to $10,000 for those who attended the school for fewer than 5 years, and up to $15,000 for survivors who attended for 5 or more school years. And the reason that we say up to is because if the $27.335 million runs out, then every experience payment will be decreased proportionately a little bit until we get under the $27.335 million. We have gotten some statistical analysis of the number of survivors and the likely number of survivors as of the December 2003 date. So we think it's unlikely that we will exhaust the 27 million, but if we do, there will be that reduction. Everyone will get reduced to the same percentage. The second pot of money in the Canada settlement is the legacy fund. So as Margaret was mentioning, the legacy fund is intended to benefit not only survivors, but also family and community. And the purpose of the legacy fund is to fund projects, as the name suggests, that rebuild the legacy for survivors. So target areas include language, culture, wellness, commemoration. The idea of the Legacy Fund is flexible, but the idea is that Canada pays $10 million, that money is invested, and hopefully it lasts a long time and is able to fund projects that build community for survivors and their families. And if there's extra left over from the $27.335 million for the experience payments, that will also go into the Legacy Fund. And then there's two other pools of money involved in the Canada settlement. The first is administrative fees. It costs a lot of money to administer a settlement. That's being paid for out of a $5 million fund separately from the payments to survivors and to the Legacy Fund. And then legal fees of $8.5 million plus tax are also being paid separately by Canada, so no reductions to the $27.335 or the $10 million will be made because of administration or legal fees. And we just put together this chart here to show you the relative value of the Legacy Fund. A fund like this is a fairly common feature of previous settlements that Canada has completed with survivors. So at the bottom there is this case about the Île-à-Crosse school, and then above you can see boarding homes, day scholars, day schools, 60 Scoop. And we just wanted to show you this because it emphasizes how important the Legacy Fund was to the plaintiffs and the steering committee in negotiating this settlement, of course, to address the harms that were done, not just to survivors, but also to family and community, and to hopefully have this money to build from moving forward.
So next we're going to talk about the Saskatchewan settlement. What happened here is, just to give you some context, Canada came to the table first and said that they were prepared to settle, but they were only prepared to pay these experience payments and the Legacy Fund and the other money that Tina just talked about. They were not prepared under any circumstances to make any payments for any kind of personal harms, physical abuse, sexual abuse that any of the students suffered at the school. This is part of the challenge that this lawsuit has been struggling with over 2 decades, because neither Saskatchewan nor Canada were admitting that they were responsible for this school, which made it very different than the schools in the Indian residential school settlement and some of the other settlements that have followed from it, where the federal government was involved, acknowledged it was involved, understood that they had responsibility to the students who were there. Île-à-Crosse was different because it was labeled as a Métis school, and the federal government, as you know, until 2014, said that the Métis people were not part of their responsibility. And the Saskatchewan government said, well, it's a residential school. It's not our responsibility. They're not, we're not responsible for anything that went on at that school either. So they were pointing the finger at each other and pointing the finger at the church, saying this is a run by the Catholic Church, not our problem. And so for the last 2 decades, part of the challenge that we've been struggling with, that the plaintiffs have been dealing with, that the steering committee have dealt with in trying to get the governments to the table, is that they've all said, not my problem, which is, in our view, an outrageous position to take. And it took up until the point where we were about to go into court to ask the court to approve this case to go forward as a class action before Canada was ready to come to the table. But they said, you know, we have lots of good arguments. We don't think that we have responsibility for this school. So we're not prepared to pay for individual harms that happened there. So that, we reached the agreement in principle last year about this time, and it took a full year for us to negotiate the final terms. We were just getting ready to go back into court because the date had been pushed off because of the settlement we reached with Canada. Just getting ready to go back into court again to get the action certified against Saskatchewan, when finally, at the end of last year, the Saskatchewan government said, yes, we're prepared to settle this action too. And what they agreed to do is a little bit different. They agreed to pay a total amount of $40.2 million. And they said that covers all of our responsibility. You decide how you want to allocate that, but it needs to address legal fees, individual harms, healing and wellness issues, and the costs of the administration. Whereas Canada had broken it up into pieces, Saskatchewan lumped everything all together. So faced with this and knowing that there was a big hole in the Canada settlement that didn't include any compensation for abuse that the survivors had suffered, the plaintiffs and the steering committee said, we need to make that a priority. So the decision was made that after the legal fees, which are going to come off the top, the balance of the money would be used as a priority to go for payment for serious physical harms and sexual harms. And the amount of the payments, there's 4 different levels, will be up to $50,000 for the lowest level, up to $235,000 for the most serious harms that survivors may have suffered. Now again, we say up to because we have a fixed fund that's available. So hopefully there'll be enough money in the fund that each person who has a serious abuse claim will be able to be paid the maximum amount. But just like with the experience payments, if there isn't enough to pay everybody the full amount, it will get reduced proportionally till the whole of the fund is used up. The committee was very, very aware that the day students and the resident students were being treated the same under the Canada settlement, which was something that Canada wouldn't move on. They insisted that there just be the 10 and 15 for all students. We couldn't move them on that point, but the committee, the plaintiffs, realized that there are additional harms that were suffered by people who had to stay in residence. So how we're dealing with that under the settlement as proposed is that to the extent that any of the Saskatchewan money isn't used up for the abuse payments, the balance that's left will then be used to pay an additional experience payment to students who lived in residence, the survivors who were in residence. So we acknowledge that there were additional harms that were suffered by the residential student survivors. And this is the way that the committee and the plaintiffs decided that this was the best way to balance all of the competing demands for the money when we've got limited pools. That Canada had dictated the experience payments and how much they would pay for that, and that couldn't be adjusted. So out of the Saskatchewan settlement, priority to the abuse claims, and then anything that's left will go to the residential survivors. There's, so this is how we see the Saskatchewan settlement funds being paid. Off the top is 8.5 million for the legal fees for the law firms who've been prosecuting this case over the years. We expect it'll cost about $1 million on top of the administration that Canada's paying for to administer the abuse claims, which leaves roughly $30 million as compensation for the abuse claims and the extra experience payments. And then we're at what happens next, and Tina's going to tell you that.
So in a class action, before a settlement can move forward, it has to be approved by the court. And the reason it has to be approved by the court is because somebody needs to be an objective observer and conclude that the settlement that the defendants and the plaintiffs put forward is fair and reasonable and in the best interests of all the class members, including survivors and the survivor class and the family class. So there will be a court hearing at the Court of King's Bench here in Saskatoon on Spadina, just next door. And that will take place on March 30th and 31st, so in about a month and a half. And at the hearing, the lawyers for all the sides will present their evidence about the settlements, and the judge will also hear directly from survivors and family about their thoughts on the settlements. The judge will also review the legal fees requests, so no legal fees will be paid unless they're approved by the judge as well. And the judge will also consider whether the plaintiffs and steering committee members should receive honoraria payments for the hard work that they've done over the many years that they've been moving this action forward. Oh, yes, and sorry, the honoraria payments, I should have mentioned this, are part of the money that's being paid separately by Canada. So the honorary payments also do not come out of the 27.335 for experience payments or the 10 million for the legacy fund. It's part of a separate pool of money that Canada is providing. In terms of what your options are now, if you support the settlements and the legal fees requests and the honorary requests, you don't have to do anything right now. There's nothing required of you. The court will consider all of those things and make a decision, and then there'll be more information provided about what is happening. If you don't agree with either of the settlements or the requests for legal fees or the honorary payments, you can send what we call an objection. And you can do that in writing, or, as I mentioned, you can come to court and speak directly to the judge. Or if you're not able to be in Saskatoon on March 30th and 31st, you can attend virtually and speak to the judge that way, or you can even call in and speak to the judge over the phone. So however you want to participate, whether it's not participating at all or all the way to coming in person to meet the judge, that is something that we will help you to sort out. And if you go to the ilexsettlement.ca website, there will be instructions about how to do any of that. Oh yeah, we don't have the link yet from the court, so it probably won't be posted until about a week before the hearing. So if you don't see it before then, don't worry, it will be up. We've already started working with the court about getting the online and everything set up.
So the compensation, as we've said, it's not yet available. The court first has to decide whether or not it's going to approve the settlement. If it does approve the settlement, then there will be claim forms that need to be completed to make your claims as either a survivor or the executor or the heirs of survivors. There will be lots and lots of information that we'll provide to you if the settlement is approved. We'll have additional town halls. There will be information on the claims administrator's website and the lawyers' websites. We'll have people available to answer calls. We'll be coming up and holding sessions to help people complete their claim forms so that, and it won't be all public like this. We'll make it individualized and private. But you'll get lots of assistance from the lawyers. But we're planning to make the forms as simple as possible so that you don't need lawyers' help if you're just making an experience payment. And if you want help, it will be available, both for the experience payment claims and for the abuse claims. The lawyers, as I said, we're going to come up and we'll be here to help. We're going to come north into your communities to provide assistance over that time. It's important to understand part of what the lawyers' fees are for is to help you with these claims. So you don't need to hire another lawyer to help you. The fees that are being paid out of the two settlements are to cover our assistance over the next several years to help with the claim forms and to help you guide you through that process. So unlike other settlements in the past where folks had to hire their own lawyers and the lawyers took a piece of whatever was awarded to them, our fees are being covered out of the settlement and are meant to assist you with that, so you don't need to pay someone else for it. Oh, yeah. So one of the things that we've learned from the experience of the past many settlements that have happened, that there have been some challenges when people put in their claims. It's been adversarial in the earlier ones, less adversarial in the later ones. There's no role for Canada or Saskatchewan to challenge the claims that are going in here on this settlement. So it's all just going to be decided based on the information that you provide to the claims administrator. We have lots and lots of information that we've gathered from many, many different sources that will be used by the claims administrators to help understand your claims and to confirm that you were survivors, that you were at the schools, and to the extent that we can to back up all of your stories. We've gathered information from the provincial archives, from the school board, from Canada, from Saskatchewan, as well as the Truth and Reconciliation Committee, and from other survivors who've been sharing their information over the many, many years. So we have lots of information that the claims administrators will have to assist them in when they're looking at your individual claims. But one of the other things that we learned and have, we think, improved on from previous settlements is that in the past, if the claims administrator didn't get enough information to approve a claim, or it was incomplete in some ways, they would send out a letter to the claimant, and they would say, your claim has been denied. And we know how traumatic that is. After all of the work that's gone into creating a claim, to expose yourselves to strangers who have to make a decision about your claim, to then be told that it's being denied or that it's not being accepted at the level that you expected. So we've built into the claims process something to avoid that happening. So when your claims go in, if the administrator thinks it's incomplete or they're going to not allow it at the level that the claim was being made for, instead of getting that denial letter, we have a claims, we're calling them an adjudicator, but they're not really an adjudicator, they're a helper who will take what the claims administrator says needs to be done to fix the claim to make it acceptable. It will go to the adjudicator who will reach out to each of you personally and help you to fill in the information that's missing, to get the other information that the claims administrators need in order to validate the claim and help you through that process. So in that way, there's not going to be as many, and hopefully no, claims that are denied just because information was missing. We've built into the process a way to complete it without becoming an adversarial process.
A little bit more about the timeline. We were finally able to get the settlement agreement signed at the end of January. And then we had to get court approval of what's called the notice plan, which is where we do things like this, give you notice, explain what's going on with the settlements, give you more information about your options. And that's all leading up to that settlement approval hearing that we were talking about that's taking place on March 30th and 31st. So the judge will not make a decision on those dates. What will happen is she'll hear from everybody, and then she'll take all that away. She'll think about it. It's a it's a very important decision to make. We want to be sure that she's got everything, that she's thinking it through carefully. We anticipate we'll get a decision probably in about 4 to 6 weeks. And so after the court decision is received, if the settlements are both approved, then we have planned for the claims period to start 30 days later. If only one of the settlements is approved, then we're going to have to rejig our processes a little bit. It might take a little bit longer for the claims process to start, but not too much longer past that 30-day window. And if neither of the settlements are approved, then we go back to the litigation process. So as Margaret was describing, it's been a long journey to get to these settlements. And it is possible that they are not approved. But if that's the case, it's extremely unlikely that Canada or Saskatchewan would be willing to negotiate a different deal. They've made it pretty clear that these are their sort of best and final numbers, at least right now. So we would go back to the court litigation process. We'd go back to the certification hearing that Margaret was telling you about, and we would keep moving forward with the lawsuit. It's hard to predict what that timeline would be if we have to go back to fighting in court, but certainly several years before we would get to a trial where we would be hoping to get a compensation for survivors and family. Oh, yes. So sorry, just to go back to if the settlements are approved, the claims period we're projecting will open summer 2026, hopefully early summer 2026. But as you can see, there's a couple of moving pieces. And then we're projecting there'll be a 1-year deadline for people to make experience payment claims. And then a longer 2-year deadline for people to make abuse compensation claims. And of course, that's because we anticipate that it may be difficult to get started or to complete your abuse compensation claim. So we wanted to give people more time to get that done, and there will be supports and assistance available throughout those time periods for help with claims. It's not just at the beginning or the end. For the entire claims period, you'll be able to access legal supports. There will be supports available through the claims administrator. You'll be able to access support in Dene or Cree or Michif if that's easier for you to access the claims process as well. And we have our contact information listed up here for those of you who don't have it. So the ilexsettlement.ca is the website for the administrator, Deloitte. And then the three law firms involved are Margaret's firm, Sotos, my firm, Goldblatt Partners, and Dwayne's firm, Merchant Law Group. And so our contact information is also on all those pieces of paper that are floating around. So you can take a picture here or just keep one of those pieces of paper. I also wanted to remind you to please, if you haven't already, take a moment to see our colleagues, Jamie and Emil, and I'm sorry, I forget your Alicia or Lisa over there. So they're taking people's contact information down so it's easier for you to receive updates about the lawsuit. We heard from some people, oh, I only heard about the town halls from my friend or my family, and we want to make sure that as many people as possible are getting direct information about what's going on. So if you sign up with them, that will help us do that.